Good evening, and welcome to the Office of the Appellate Defender's first Monday in October. My name is Nick Borton, and I'm proud to serve as the chair of the board of OAD. Many of you have been to our first Monday event before, and we're sorry that we can't all be together again this year. We hope that the silver lining of holding First Monday virtually is that we'll reach an even bigger audience and spread the word even more widely about the amazing work that OAD does on behalf of indigent clients appealing their convictions in New York State Court. Now more than ever, we need OAD and organizations like it. Public defenders and nonprofit criminal justice organizations like OAD are the great levelers of inequality. They are the unsung heroes in their struggle for racial and criminal justice. It is our mission to work to fulfill the promise of equal justice under the law, one client at a time. I want to thank all of our sponsors who made tonight and OAD's work more generally possible. We rely on your generosity and are so grateful for your support. I hope that those of you who are watching who have not yet contributed to OAD will give what you can to help us in our mission. I also want to thank our participants, the lawyers serving as justices of our mock Supreme Court, and most of all, Sharon Nellis and Robbie Kaplan, our Gould Award winners who are going to argue the issue of qualified immunity. So thank you for tuning in tonight and for your support of OAD. It means the world to us. Let me now turn things over to Stephen Chu, OAD's interim president and attorney in charge, to get things started.
Thanks, Nick. This question about equal justice under the law is difficult, especially with the passing of Justice Ginsburg and the lack of charges in Breonna Taylor's death. Many are asking whether justice in our legal system is even realistic. You're about to hear an argument on qualified immunity, which directly presents this issue on all fours. It's also the question that our staff wrestle with every single day. OAD attorneys are amazing litigators. They craft arguments that persuade. They do briefs that win. Marvin Clark, who you will hear from in a second, is an example where our advocacy also serves to educate the courts about the many problems in the mass incarceration system. But each person on staff can also tell you about clients who equally deserve relief, and the courts have said no. These are often the cases that keep us up at night, and it's why OAD believes in advocacy on all fronts. We routinely walk clients out of prison because we reinvestigate cases that others have given up on. We advocate for parole because 20 years, 30 years in prison is more than enough. And in the last 6 months, our attorneys have spent hours talking to and fighting for our incarcerated clients who are incredibly vulnerable to coronavirus. I'm proud to be a member of this team. They have not stopped working 110% even during this pandemic. I hope you get a chance to meet them after the stream in the post-video rooms below. Thank you so much for joining us.
Hi, I'm Gabe NEWLAND. I'm a third-year staff attorney at the Office of the Appellate Defender, and I'm pleased to be presenting this year's Beacon of Hope Award. The award celebrates a former OAD client whose life stands as a powerful example of the human capacity for resilience and highlights the importance of centering the administration of criminal justice around the inherent potential of every person. OAD's 2020 Beacon of Hope Award goes to Marvin Clark. When I argued Mr. Clark's appeal last fall, he'd already completed his prison sentence, but we persuaded the appellate division to reduce his post-release supervision by 1 year. Emphasizing the support Mr. Clark would have from OAD's client services program, we successfully argued that Mr. Clark did not need an additional year of post-release supervision, which came with a curfew, restrictions on his ability to visit family out of state, and the looming threat of prison, to stay on the right track. Today, Mr. Clark has an apartment in the Bronx, and before COVID struck, he was working 6 days a week at Caputo's Bake Shop, an Italian bakery in Brooklyn, where he hopes to resume working again soon. So congratulations, Mr. Clark. Do you want to hold up the award?
I would like to say thank you. I really appreciate this award. What makes me appreciate it even more is to know that, people are looking even when you don't know that they're looking. It feels good to know that, somebody appreciates some of the hard work and the things that people do, and they acknowledge the fact that a person is doing what they have to do in life. And I really appreciate that. Thank you.
Do you have any advice for young lawyers who are working with people in prison and people who are coming home from prison?
I would say you're not really there to judge, you're there to do a service for the client. It never hurt to hear the client out. Some people are way sharper than other people when it comes to articulating words. But if you take the time out and listen to them and hear it out, it's there. Like the proof is always in the pudding. It's there. You just got to take your time out and listen. There was a lady here. Her name was Miss Aaliyah Johnson. And she also pointed me in the right direction to do certain little positive things and a couple of programs I remember where I could go to pantries and get food. Then my lawyer also helped me a couple of times to get things that I needed for soap and toiletries, food and things of that nature, because when I first came home, it was like I was lost. There was a lot of things I just didn't know where to go.
For any other OAD clients who are coming home, do you have any advice for them?
It's 3 steps, It's crawl, walk, and run. It's not very easy. You have to dedicate your time to trying to do what it is to take care of the things that you have to take care of. What I say for anybody that's, coming home is to just hang in there, take it one day at a time. There's a whole bunch of help out there, but you just got to look.
Congratulations again, Mr. Clark. It was wonderful working with you, and congratulations.
Thank you. And once again, I love this award. I appreciate it, and I'm going to cherish it.
The Gideon Award honors a law firm for its exemplary participation in indigent appellate defense through OAD's Volunteer Appellate Defender, or VAD program. It allows attorneys at member law firms to devote their time and energy to public service while also providing these lawyers with valuable mentoring and hands-on experience, including appearing before the First Department of the Appellate Division to present oral arguments on behalf of their clients. This year's recipient, Jones Day, has participated in the VAD program since the program's inception, more than 25 years ago. Jones Day lawyers have worked on dozens of criminal appeals, providing extraordinary representation in all of those cases. Most recently, Don Goodson and Mayor FELDER agreed to work with OAD attorneys to draft a Court of Appeals amicus brief in a pair of cases challenging the admission of low copy DNA and the use of forensic statistical tool FST in DNA analysis. The amicus brief produced by the Jones Day team was masterful. It presented a compelling and accessible case for the need for a FRI hearing to scrutinize the admissibility of those controversial types of forensic evidence in the Court of Appeals decision requiring FRI hearings in the cases of People versus Williams and Foster Bay. Jones Day's exemplary contributions to the VAD program are a reflection of the long-standing commitment of the firm to OAD. And that commitment goes beyond Jones Day's participation in the VAD program. It is also reflected in the dedicated work of Jones Day lawyers on OAD's board of directors. Retired Jones Day partner Tom Heyman has been with the organization since day one, serving for over 2 decades as the chairman of OAD's board. And Jones Day partner Mayor FELDER joined the board of directors in 2011 and has worked tirelessly on OAD's behalf ever since. Accepting the Gideon Award for Jones Day is Mayor and Lee DeJulius, the partner in charge of Jones Day's New York office.
For the occasion of this award, and here is the award, I took the opportunity to look over our VAD cases for the last 10 years. There were a few things that caught my eye that I thought I would share. First of all, I was reminded of several that were successful. There was one where the First Department found insufficient evidence to convict. Another, the First Department overturned a conviction because the trial court failed to adequately test the prosecutor's challenges that were alleged to be based on race. There's also another brief that I ran across that was filed in November 2014 by our then associate Vanessa Nadal. Now, why am I mentioning the date? It's because at that very same time, Vanessa's spouse, Lin-Manuel Miranda, was deep in rehearsals for the premiere of Hamilton. And Despite everything going on, Vanessa, if you will excuse the expression, was not going to throw away her shot to participate in the important work of the VAD program. More generally, I was really gratified just at the sheer number of cases that we've handled, win or lose. Even when a conviction is affirmed, our system depends on the work of lawyers doing their best to keep the system honest and to ensure that defendants' rights are protected. And so, although we're the ones receiving the award tonight, I think we owe a thank you to OAD for giving us this opportunity.
Thank you, OAD, for the recognition and for the Gideon Award. We at Jones Day are proud of our pro bono record. In 2019 alone, we incurred more than 119,000 pro bono hours, totaling almost $120 million on causes ranging from unaccompanied minors and women at the southern border, protecting the right to peacefully protest, fighting hate crimes and combating human trafficking, and of course, dedicating our time to the longstanding partnership with OAD that goes back more than 25 years. Over the time that we've worked with OAD, every one of our New York appellate lawyers and many of our trial lawyers have supported OAD. It is in our culture to do well by doing good in our communities. We are proud to have helped in our minor way and look forward to doing so for years to come. Thank you.
Before you see them all in action, let's spend a couple of minutes introducing and talking to our honorees for the Council for Justice Award, Danielle Gray, and the Gould Award for Outstanding Advocacy, Sharon Ellis and Robbie Kaplan. Let me also introduce my fellow board member and the person I succeeded as chairman of the board of OAD, Sean Hecker.
Thanks, Nick. Let me just say it's a real honor even to be on the same screen as this trio of amazing honorees, each an incredibly impressive, talented lawyer. I think it's so fantastic that this year we also have 3 women honorees. That's just a really, really terrific sign of where we are. And let me start with Danielle Gray, who has been a friend and who once served on the OAD board, which makes it particularly meaningful from my perspective that we're able to honor Danielle with the Council of Justice Award. Danielle, you've had this unbelievable career, having served as a clerk on the Supreme Court, having worked in the Justice Department, working in the White House counsel's office, and at the tender age of 35, serving as cabinet secretary to President Obama. You've had this just unbelievable opportunity in these multiple roles to see the way in which policy change can happen. And so first, I want to congratulate you, welcome you back to OAD. You're just a phenomenal honoree for us. So congratulations for all that you've accomplished.
Thank you so much, Sean, and thank you to OAD for honoring me. I'm quite humbled by this. I have the award here with me at home. And when I think about Council for Justice, I think about the men and women who work at OAD and case by case are trying every day to make our justice system more just and more fair for a number of people. I'm very honored to be a part of this program along with the other honorees. I am familiar with OAD in part because I was a board member when I lived in New York. And so I had a chance to see up close the great work that the organization does on behalf of its clients. And I really think of it as a top law firm. You know, this isn't a great event because a lot of the legal community, law firms in New York, corporations come together in support of criminal justice and indigent defense. But I think of OAD as one of those top law firms. And so it's really great to be a part of this.
Let's now turn to our Gould Award honorees. For reasons that will be obvious, I am particularly excited this year to honor and congratulate my partner, Sharon Ellis. I've known Sharon for more than 20 years, and she is one of our country's leading litigators. Most lawyers who litigate against Sharon find themselves both irresistibly liking her and yet at the same time wishing they had gone up against somebody else. She is on the management committee of the firm, and she is herself the managing partner of our litigation practice. And yet with all that client responsibility and management work, she still finds time to give back to the community, whether it's her tireless work for breast cancer awareness and research, helping to establish the New York chapter of Time's Up, or being one of New York's strongest advocates for diversity, and in particular, the advancement of women in the legal community. Sharon represents all of our best aspirations for the profession. So congratulations, Sharon. I'm thrilled, and OAD is thrilled to honor you tonight.
Thank you so much, Nick. I am thrilled to be honored. I feel also humbled to be here on this screen with this group. I spend, as you say, a lot of time managing the litigation group, managing the firm. So I thank you all, not only for this honor, but to force me back into some books and start to learn a little constitutional law again. I picked up Gideon v. Wainwright again, and thought about what it means to have a lawyer in a courtroom, and ran across a comment about how what Gideon did was establish not so much a constitutional right, but a constitutional aspiration. And that's because Gideon is a mandate without funding. And that's why what you all do is so critically important. Without you, what we do is relatively, frankly, meaningless, because then it's just justice for some. And your goal is justice for all. And that is why when you asked me to do this, I only hesitated for this long before I said yes. But incredibly honored that you even thought to ask me.
Well, I think it's my turn to have some fun in congratulating my partner, Roberta Kaplan. Robbie, as she's known by, I think, everyone at this point, is a force of nature. When I asked Robbie to go to lunch with me to talk about why she left her great perch at Paul Weiss after winning the Edie Windsor case and establishing the right for LGBT folks to marry their partners, by the end of the lunch, the next thing I knew, I was joining Robbie and leaving my perch at another great New York law firm. She's managed to combine a first-class commercial litigation practice with a public interest mission that has our firm and Robbie in the lead, taking it to the system. You're a most deserving Gold Award honoree, and it gives me great pleasure to be the one to be able to congratulate you as one of this year's recipients.
When I first got a call about this award, I think I noted on that very call that I was so touched, because many, many, many years ago, I was a clerk for then Chief Judge Kaye on the New York Court of Appeals. There was one advocate. Whenever he appeared before the Court of Appeals, I went to see him argue, and that was Milton Gould, who was simply the best oral advocate I have ever seen in my life. So it is such an enormous honor for me to have anything to do with him, because he was such an enormous talent. And I'm afraid that young lawyers today don't realize the legacy that we inherit from people like Milton Gould. The other thing that makes this incredibly special is it's not common to be getting an award and then to have to do a moot court against one of your closest friends. Sharon Nellis may be a friend and a mentor to the other lawyers at Sullivan and Cromwell, but she's also a friend and a mentor to me. She is the person I call whenever I have a tough judgment call to make, and not once has she ever let me down or has she ever been wrong.
And if I may, the only reason I hesitated this much is because she may call me, but I have seen her in court more than once. So this is going to be something for me. I know what I'm going up against.
It couldn't be more obvious today how much our country needs the lawyers at OAD, how much it needs to focus on issues of racial justice within our system, both in terms of individual cases that OAD represents defendants, in terms of the system overall, in terms of legal change that Sharon and I will be arguing, and in terms of changing our system so that we're not stuck into these racist patterns over and over and over again. And I am so honored to be here with lawyers like my partner, Sean, and like the other board members of OAD and the lawyers at OAD who deal with these issues every day.
We saw this unbelievably dramatic and, relatively speaking, quick change when it came to the issue of marriage equality. And here we have an issue that has been with this country since its founding. And let's talk about it specifically in the context of the criminal justice system, where issues of racial inequality have been pervasive for such a long time. The issue that you'll be arguing around qualified immunity and It'll be fun for all of us to see you on the side of the status quo for the first time in a while. What are your thoughts about whether this is an issue that ought to be fought in the courts or in our political system through legislative change? I'd be interested in your thoughts, and then maybe we can open it up because I suspect all of us have some views about that.
So in the context of LGBT rights, I have spent a lot of time thinking about how, relatively speaking, we achieved so much progress so quickly. It seems like a nanosecond in terms of other civil rights movements that LGBT people, at least in this country, were able to move from really being second-class citizens to almost achieving full equality, or at least achieving it pretty close to it under federal law. I think the most important thing that we learned from the LGBT rights movement, and it's not me, it's from people whose shoulders I stood upon, that you have to fight these issues, I think, in all venues at once. So the media is incredibly important. Honestly, Hollywood is incredibly important. Having movies and TV shows that talk about these issues has a huge impact on the American public. Getting legislation passed slowly but surely through states and then through the federal government, and ultimately the courts as well, that you can't only look at one piece of it, that the way to achieve success is to look at all of them and kind of have all gears going completely in all venues at the same time.
I want to echo what Robbie just said, and I am a huge admirer of Robbie's work and what she was able to do to advance LGBTQ equality. And when I was in the executive branch, I saw this approach, this sort of all of the above strategy every day. And I think what is really powerful about that, and I think what can inform how we think about this with some of these issues of structural racism and criminal justice, is it starts creating a drumbeat. So this change happened really quick, but it just felt like the winds were bending that way, in part because there was this sort of all of the above strategy. And so I think there's some important lessons in that, and that probably can be applied when I think about steps that police departments around this country can take, and the role that the Justice Department or DA's offices in New York and other cities across the country can play in reforming some of those practices. To me, that work is just as important as continuing to press the courts to overrule parts of the qualified immunity doctrine. And in all candor, it may happen quicker.
What we're doing with this particular event and focusing on this particular issue is really instructive about how it has to be a more than courts approach. And until there is a community that comes forward and says, it's not acceptable, and this is something I think Robbie showed so completely in Windsor, and I remember listening to that argument where it was the comment made about tides of change, and this is what the country is ready for now. How the law follows the country doesn't follow the law. As a society, we don't have a choice to decide to take a slow path through the courts. We have to do this in a much broader way.
Danielle, Robbie, Sharon, thank you for all of that. A lot of really important and powerful things to think about. And we will now turn to the actual representation of what people at OAD and what people fighting for criminal justice do every day, and have an argument that shows, in addition to what's happening at the political level and the decisions of our leaders, there are still people every day who have to fight the battle in the trenches. This whole event is to honor those people. But thank you guys so much for participating and for the really thoughtful views you've given us tonight.
In 2014, Alexander Baxter was spotted stealing from a house. He fled to a nearby basement and was surrounded by police, who asked him to surrender. Mr. Baxter claims that he sat down and he raised his arms. But at some point after that, Officer Harris released a canine police dog who bit Mr. Baxter under his arm. The parties do not dispute the dog's attack, but there is disagreement over the other details. How much time elapsed? Did the officers see his raised hands? Mr. Baxter argues that the officers are liable because they used excessive force. One Sixth Circuit panel ruled that this is a question that should go to a jury. However, a second panel, looking at the same facts, said that the police were entitled to qualified immunity. In other words, the law did not clearly establish that their actions were unconstitutional. As a result, the case was dismissed. So we're here tonight to ask two questions. One, should this case have been dismissed? And two, should this court change its doctrine on qualified immunity? Please join me now in the virtual courtroom of the mock Supreme Court of the United States as I invite the court crier, MYRNA FELDER, to open our session. The time is 10 a.m. The day is the first Monday of October 2022.
The justices of the mock Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the mock Supreme Court of the United States shall draw near and give their attention, for the court is now sitting. God bless the United States and this honorable court.
The court will hear argument in number 18-1287, Baxter versus Bracey. Ms. Nellis, we will hear from you first.
May it please the court. This nation has always struggled to realize our founders' vision of a more perfect union. Shamefully, from our very beginnings, the blessings of liberty that were promised by the Constitution have not been equally bestowed upon all Americans. Today, we have people marching in the streets, as we did in 1963. And in 1963, the late Congressman John Lewis said, "We cannot be patient." This court has answered the call in the past. It answered the call when it issued its unanimous decision in Brown v. Board of Education and resigned, separate but equal, to the dustbin of history. Today, this court has the opportunity to answer the call of courts around the country and call of several of you justices, and do the same with respect to the doctrine of qualified immunity, which is a judge-made doctrine that has taken a statute designed to protect people from the government and turned it on its head to protect the government from the people. This is a court that decided Dred Scott, but it also decided America v. Windsor. This court can change bad law, and it's time to change this bad law. The doctrine of qualified immunity is atextual and it is ahistorical. Neither qualified immunity nor the developments of qualified immunity are found anywhere in the text of Section 1983, which admits of no immunities. The court
Ms. Nels,
yes.
That may all be well and good, but this court has heard qualified immunity cases several times over the last few years, and 2 years ago, we ruled the doctrine applies unless existing precedent squarely governs the specific facts at issue. Are you asking us to overrule those cases?
Your Honor, since 1967, this court, through Kutsud like creep, has turned qualified immunity into a situation where unless an act is clearly established as a constitutional violation, it is beyond debate. Yes, what I'm asking this court to do today is abolish qualified immunity. That is the right approach. It is the approach that is most faithful to the text and the historical context of Section 1983, and it would be what I would ask this court to do today.
Ms. Nellis, do we have to go that far for your client to win?
No.
Can we not just say that the lower courts misapplied our cases that make clear that you do not need a factually identical case on point? Do we have to go as far as you're suggesting?
Your Honor, I would hope at the very least that you would clarify that Hope v. Pelzer is good law, that the courts do not need to split hairs, and may do away with the idea that plaintiffs need a case directly on point to overcome qualified immunity, and obtain redress for constitutional violations. I think that is something the court could do today, and I think it is the very least the court could do today.
Counselor, didn't our court already clearly establish that it's not necessary to have a case with identical facts in order to deny qualified immunity? Isn't that what we held in Anderson and repeated in Ziegler?
Yes, Your Honor, but this court has also been quite clear to the lower courts that the courts cannot do this at a very high level of generality. And in fact, what you have asked the lower courts to do is to make sure essentially that they have a case that is almost directly on point. And if this court upholds the case below, it is what you are telling courts below is that you must have a case expressly on point turning the doctrine of qualified immunity on its head to absolute immunity. The case below shows precisely what courts are struggling with. We had two panels of the Sixth Circuit that looked at precisely the same law and precisely the same facts and came out with exactly the opposite.
Counselor, isn't it the case that the second panel of the Sixth Circuit understood that there was a factual question as to whether the officer actually saw Mr. Baxter in this case with his hands up? Isn't that a highly relevant, different fact that distinguishes the decisions of these two panels?
Your Honor, Justice Strawber, that it's not actually the relevant consideration here, because this is a case that was brought up to the Sixth Circuit on a motion for summary judgment. The court below was quite plain that it had found that all of the facts that justified the request for damages were established in discovery. The issue here, and the only issue here, was whether or not there was any difference between a suspect who is lying on the floor surrendered and a suspect who is sitting on the floor with his hands up, the universal sign of surrender. To the extent there is any question as to whether or not the officers acted with under different facts and under the reasonableness requirement of the Fourth Amendment, that is something that should go to a jury. And certainly the idea that this court is struggling, that courts below are struggling with the question of whether they need to look to these kinds of facts underscores why today is the day that qualified immunity needs to be abolished.
1 minute, Counselor.
Counselor, one question is whether you accept the general idea that officers should not be held liable for completely novel constitutional violations.
Your Honor, my position would be today that the right approach, again, is to return to the faithful text of Section 1983. And that text would afford immunities where those immunities were established in the common law at the time. That is the Pearson rationale. If this court did nothing else but return to the Pearson rationale, if those immunities were intended to be afforded to officers, they would be afforded to officers.
Is there any reason to believe, given the fact that nearly every police officer in the country is indemnified, that if we adopt your standard, there will be any additional deterrent effect on officer behavior?
Your Honor, I think it is imperative that we abolish qualified immunity in order to have a deterrent effect on officer behavior. At this moment in time, we live in a society where it has been made plain to people on the streets that their officers act with impunity, and there are essentially no checks on their behavior, which is exactly what the Reconstruction Congress was attempting to avoid and stop from happening at the time when it enacted what was then Section 1 of the Ku Klux Act to make sure state actors did not infringe upon citizens' constitutional rights.
Ms. Kaplan, we will now hear from you.
Thank you, Ms. Chief Justice. May it please the court. 8 years ago, Your Honors, in the case of Reichel versus Howells, this court decided a case about a Secret Service agent who was protecting then Vice President Cheney. And the question in the case was whether the arrest of a citizen who the Secret Service officer had overheard saying that he was going to ask Vice President Cheney how many kids he killed today was proper, and whether it was a retaliatory arrest in violation of the First Amendment. Justice Ginsburg, may she rest in peace and may her memory be a blessing, concurred in that case. And in her concurrence, she stated as follows: I concur in the court's judgment. Officers assigned to protect public officials must make singularly swift, on-the-spot decisions whether the safety of the person they are guarding is in jeopardy. While this court has clearly said that the standard for Secret Service officers and police officers is different, and I'm not disputing that, that kind of swift, on-the-spot decision is exactly what was an issue in this case, and exactly why the decision of the Sixth Circuit below was proper, and exactly why this court should not use this case to reconsider any of the aspects of qualified immunity. And it certainly can't, as my friend in both senses, Ms. Nellis just said, abolish it under this court's precedent, since we're talking here about statutory stare decisis, not constitutional stare decisis. This is not a case like Brown v. Board. This is not a case like US v. Windsor. We're talking about a statute.
May I ask you about the statute? Where in the text of the statute do you find the basis for qualified immunity?
I am not going to argue that there is any basis in the text of the statute, but that's really, Justice Harrison, irrelevant for purposes of this court's consideration. There is a lot of historical debate. I've read Mr. Bowd's article. There's a lot of historical debate about the state of the law in the 19th century before the KKK Act of 1871 was passed. Having read both sides of that argument, I think at best it's inconclusive.
But if there's not a basis in the text of the statute, how can you argue for application of statutory stare decisis?
Because when this court construes a statute as it has and applies it for 50 years, then particularly at a time today, and this is something also my friend referred to about the horrible controversies and divisiveness in our country today, it is not the role of this court then to abolish that statute. The role of that and whatever reform needs to be made with respect to qualified immunity, as this court has said, is in the hands of the body of government across the street, the United States Congress. And I would respectfully suggest that it would diminish the public's respect for this court for it to make that kind of a radical change and its interpretations of decision when it's interpreting a statute.
Counselor, I'd like to bring you back to the factual record of this case, where in all of the proceedings below, Mr. Baxter was pro se. And I find the record that has come up to this court to be really wanting. I mean, tell me if I'm wrong, but it seems that there has really been no factual development of whether the basement was light or dark, whether Mr. Baxter was sitting or standing when the police entered the basement, whether they could, I know there's a dispute about whether they saw his hands, but what about whether he was sitting on the floor, not fleeing, not providing any resistance?
Yeah, Your Honor, I agree with that. And there's really an argument here, given the undeveloped nature of the action below, whether this case was improvidently granted. I would respectfully suggest to Your Honor that the court is to consider these serious issues of qualified immunity. It should do so in a case with fuller factual development and where both sides of the case are fully represented. But
well, Counselor, that's a convenient position for you to take. But isn't there a sufficient record here and a sufficient obligation for this court, to the extent our own jurisprudence is being inconsistently applied, to clarify at a minimum the meaning of clearly established? And is it your position that the Sixth Circuit was correct in finding that without a case involving virtually identical facts, that qualified immunity will attach?
I think the Sixth Circuit was absolutely right in applying both its precedents and your precedents to the facts of this case. This case is not just about, as Justice Orenberg just mentioned, whether or not, how dark it was in the basement, or whether the officer could or could not see properly whether the arrestee had his hands up or his hands down. But that is precisely what I said in my opening argument. It's that kind of split second decision making.
Counselor, can I ask you about this split second decision making? There's a sentence in your brief I want to read to you because I found it jarring. It says, the end of your brief, in fact, behavior like that of the officer in George Floyd's case is clearly excessive force, and qualified immunity would simply be denied. And I'd like to know how you're so sure of that. It strikes me that if you were representing the police involved in Mr. Floyd's case, you might be making similar arguments today about what's clearly established under law. As I understand it, Mr. Floyd's hands were not in the air. You've said in this brief that maybe, and the lower court said below it, maybe not, would it even matter whether or not his hands were up in the air? And your brief cites a bunch of cases for the proposition that the excessive nature of the force and the fact that the force may have been deadly, if justified in that split second, may not have merited a different outcome. So how are you so sure that qualified immunity would be denied in that case?
So let me say,
and Ms. Kaplan, just to piggyback on what Justice Gray is saying, you invoked the late Justice Ginsburg at the start of your argument. She concurred in Justice Sotomayor's dissent in Casella v. Hughes very recently, saying that qualified immunity has in fact turned into absolute immunity. So I'd like you to take that into consideration as well as you're addressing Justice Gray's question.
Let me start with Chief Justice Gray's question. So first of all, let me contrast the facts. George Floyd, as far as I understand, Ms. Chief Justice, was not in the middle of an aggravated robbery in someone else's house. George Floyd, Ms. Chief Justice, as far as I understand, did not have helicopters above looking for him, did not have warnings that a dog crew was going to come after him, and did not ignore those warnings by going into the basement and crouching, regardless of whether the light, in a way that he thought would avoid detection by the police. The facts in this case, in Mr. Floyd's case, are completely different. And I don't want to be seen to be defending the police action in Mr. Floyd's case, because that is clearly reprehensible. And let me just turn for a second to the deterrent nature and the deterrent policy issues that are being brought here. I too have read much of the academic literature about this. And in cases that are so discussed in the public today, and for good reason are discussed in the public today, like Mr. Floyd's case, there is no basis to presume that officers who commit horrible acts like that are being entitled to qualified immunity, number one. Number two, as a lawyer who works in the civil justice system, and as a civil lawyer who deals with civil cases all the time, there's not even good reason to assume that that would act as a deterrent. What would act as a deterrent is criminal prosecution of officers who behave like the officers with respect to Mr. Floyd, and disciplinary action by the police departments when such accusations are made. This is only about whether the victim can recover money, and as has already been mentioned, in the vast majority of situations, the police departments in the municipalities indemnify police officers where it's found that qualified immunity does not lie.
Counselor, aren't you asking us to play the role that traditionally the jury has held, that we have taken on a qualified immunity doctrine? But for example, the Sixth Circuit has a case, Robinette, in which the dog, similar facts, but the dog bit and fatally killed the person involved there, right? And the Sixth Circuit held that the police officers were entitled to qualified immunity. So again, in our facts, had the dog fatally killed Mr. Baxter, is it your position the police officer would also be entitled to qualified immunity? And isn't this the kind of determination, as Justice Zornberg has said, that we need more facts, and maybe these facts are best suited for a jury to determine whether or not they're reasonable?
This doctor is undisputed that this dog was well trained, that the dog, it's sad that he bit this gentleman, but thank God he only bit him once. He did exactly what he was trained to do. And in the split-second decision, when that police officer had to decide whether he had truly surrendered, he said nothing, it was silent, whether he had truly surrendered or whether they were going to have additional trouble from this man. That's exactly what this court has said. Courts should not be second guessing. And that's exactly why it has developed qualified immunity. And that's exactly why, if there are going to be reforms to qualified immunity, and I'm not here to suggest there shouldn't be reforms, but if there are going to be reforms to qualified immunity, that's the job of Congress.
Isn't there a disconnect, though, between the concern you have for the ability of police officers to make split-second decisions and the remedy you're setting, which is qualified immunity, which doesn't turn on whether it's a split-second decision at all? It just turns on whether it's a well-established constitutional claim. Can you explain why, if our concern is split-second decision-making and protecting mistakes made in that context, we should use qualified immunity as the tool to achieve that?
And just one note before you answer that, Ms. Kaplan, because this troubles me too. The doctrine is built on this fiction. It's an utter fiction that police officers in this split second are parsing Sixth Circuit case law to see if the dog attack law supports them or doesn't. It's a doctrine totally unmoored from the principles behind it.
Of course they're not, but it's because of that split second situation that police officers and Secret Service officers are often put in. That's why you develop this doctrine. That's why you made the protections for police officers and public officers at such a high bar. Because of course, no one, even I as a trained lawyer, in that minute would not be thinking, is there Robinette? Is there Carpenter? Is there another case? No one can do that. But for that reason, we have to give police officers a significant degree of leeway to do what they have to do in the minute. And unless it's obvious, unless there's a clearly established decision that says that's outside the bounds, that's clearly unconstitutional conduct, we give them qualified
But
immunity.
counselor, if it's so reasonable, why not let a jury decide that? Why are you afraid to have a jury decide that?
That's a question for Congress, Your Honor. If this court wants to change its law of qualified immunity and let everything go to juries to be decided, they can do that. But this court has erected a 50-year body of law that says immunity, and that's true in any context of immunity, sovereign immunity, other kind, is an issue for the court.
But if we are going to have qualified immunity, isn't it important to be clear that we want to encourage officers to use the decisions that are out there to develop principles of their behavior so that they're staying within constitutional boundaries? Doesn't your argument disincentivize officers to do that? Because any new set of facts will be one in which there's no clearly established law?
So, Your Honor, I was reading some of the press about this case and preparing for the argument. And a person who was the head of the New York Association of Police and talking about the facts of this very case said that there is no way for me to train somebody as to every possible scenario of when you release a canine and when you can't. That's exactly, again, that's obviously out of a matter of simple common sense true, and is exactly why this court has built this doctrine. Can you tinker around the edges as you have as to what the standard is for clearly established? Sure you can. But you can't, as my friend Ms. Nellis says, abolish the doctrine. And even if you're going to tinker around the margins, I would respectfully suggest that this is not the case to do it in, because here it's so clear that the doctrine of qualified immunity applies.
Thank you, Ms. Kaplan. Ms. Nellis, you now have 3 minutes for rebuttal. And if I may, I'd just like to start by picking up where Justices Moyne and Strauber were going with your sister about the factual record before us. I know that we have a declaration from Officer Harris saying he did not see raised hands. Do we know what the other officer said he saw?
We do not, Your Honor. What we know is, and what doesn't actually matter here because we are on a summary judgment standard, what we know is that there is no dispute that the testimony as it had come in through discovery is that the suspect was on the ground, hands up, 4 to 5 seconds before the officers released an attack dog unit on him.
Counselor, what do we do with our precedent, right? We have a case in Kisla where we held that an officer could shoot someone 4 times who was holding a knife, not a gun, and was not a threat to the officer, right? So that officer is entitled to qualified immunity. And then the Sixth Circuit has a case where they allowed qualified immunity when a dog fatally bit a suspect. So do we have to overturn those precedents?
Justice Moyne, you have picked up exactly what the issue is, and it leads to the answer, yes, it is time to abolish qualified immunity. I believe what you just heard Ms. Kaplan argue is that that qualified immunity doesn't matter because it's only about a victim recovering money. I heard her say that you should build a reprehensibility element into the doctrine of qualified immunity. George Floyd is obviously reprehensible. I agree. Sicking a dog on a surrendered suspect is also reprehensible, I would argue. And the courts cannot decide. They cannot decide among the circuits. They cannot decide within the circuits. They cannot even decide within panels. This is not an issue for Congress. This is a judge-made doctrine that this court has changed over and over and over again, from objective to subjective. This court has regularly modified this doctrine.
Isn't it the case that the victims of improper police activity have a number of other venues for seeking financial redress beyond the type of suits that you're asking us to authorize?
Your Honor, I would advocate strongly, Justice Jackson, that we remember why the Section 1983, why the Ku Klux Act was established in 1871, and it was to protect the citizenry from people acting under the color of law, breaking constitutional rights. I recognize, excuse me, Your Honor.
You weren't able to answer my question earlier about deterrence, and what I'm asking is there any evidence in the record to suggest that there's some gap between what victims of what is tragic and inappropriate police behavior are able to achieve through other forms of civil litigation and what they'd be able to achieve if we were to adopt your standard?
Your Honor, I believe the record was quite clear that officers today, and we have submitted studies, that officers today feel absolutely unrestricted by Section 1983. And that there's the split-second decision-making that we have been speaking about has absolutely no impact on their decision-making process. And whether that is because they are not fearful of having monetary damages, or they're not fearful of having to face a reckoning in a day of court before a jury, is unknowable. What we know is that our citizens of this United States of America are entitled to have their issues heard by a jury. Qualified immunity writes that right out of our Constitution. Ms. Kaplan herself has said that the law requires us to be courageous, that we need to press boundaries, that we must insist that things change for the better. And I believe she stood up not long ago and said, that's something we need to do now in a different context. Well, I submit that is something this court does need to do now. How much humiliation do we have to ask be endured because no court has yet addressed the precise contours of an obvious wrong? If there's no reprisal for such acts based on hair splitting, trivial case differences, or lack of a case at all because of the obvious catch-22 of allowing something not clearly decided to remain undecided, then what protections are left for our citizens?
Thank you, Ms. Nellis.
Thank you, Your Honor.
The case is now submitted.
The mock Supreme Court of the United States now stands adjourned. The court will reconvene on Monday, October 4th, 2021 at 10 a.m.
Let's start with Baxter versus Bracey. Lisa, we'll start with you.
I'm disturbed by the inadequate development of the factual record in this case. And no doubt a contributing factor to that is that the petitioner acted pro se without the aid of counsel throughout the underlying proceedings. You know, since we adopted the objective standard for qualified immunity in Harlow, the key question has been, would it have been clear to a reasonable officer that the alleged conduct was unlawful in the situation he or she confronted? That's a standard that necessarily requires our courts to assess the clarity of the law to a reasonable officer in relation to the specific facts of the situation at hand. And Justice Brennan, concurring in that standard in Harlow, noted that discovery would sometimes be needed before the immunity question could be decided. My problem here is that the record we have inherited on appeal is so sparse that it really does not permit intelligent application of the Harlow standard. If the officers entered the basement to find Mr. Baxter visibly sitting on the ground, unmoving, with his hands up, not fleeing and not resisting, okay, you found me in that posture, then I believe a reasonable officer would have known that it was unlawful in that situation to release the dog to attack. But if the facts established that the basement was dark when they entered and that Mr. Baxter was still standing wedged between a boiler and a chimney, or that he engaged in sudden movements when he could have been armed, so that it was hazy to the officers what he was doing, the law would not have been clear to a reasonable officer that they could not use a canine dog. There's a big chasm factually. So look, in our system, where immunity precludes any trial, the record is just too insufficiently developed. I believe the case should be reversed. There should be a trial, and at trial, the officers can assert an affirmative defense that they acted in reasonable good faith. On the broader question of our standard in Harlow, I believe it remains fundamentally sound and that the standard should remain intact unless Congress steps in to change it. And my view is we should decide this case narrowly on the facts before it, which are inadequate for decision, send it back, and leave it at that.
Thank you, Lisa. We'll go to Jocelyn next.
Thank you, Chief Justice Gray. I share many of the concerns of my colleague, Justice Zornberg, about the factual record here, but I think I would approach the ruling a little bit differently. I too would reverse the Sixth Circuit's conclusion that the officers are entitled to qualified immunity. And that's because as I read the opinion, the court wrongly concluded that in the absence of a case on identical facts, qualified immunity should be granted. To me, this effectively establishes a standard of absolute immunity, which is not the law and which is not consistent with our precedent. I agree, as Justice Zornberg said, that Harlow provides a sound standard, and where our cases or the relevant circuit cases establish clear principles such that a reasonable officer would understand that they govern that officer's conduct, the law is clearly established. The Sixth Circuit has two precedents on the very law enforcement technique at issue here, which is canine apprehensions. I think the standard established by the Sixth Circuit is sufficiently clear, such that officers could have made a judgment here. Even if those facts involve novel circumstances, it can be said that the law is clearly established. I would not entirely jettison the doctrine of qualified immunity, as I think petitioner would like us to do, because I do not think we want to depart from decades of precedent that serve the appropriate goal of not holding officers liable for conduct that a reasonable officer would not understand violates the law. That is, in situations where existing case law not only does not address the specific facts at issue, but fails to provide governing principles that a reasonable officer would understand apply to his or her conduct.
Thank you, Jocelyn. We'll go to Parvin next.
Thank you, Justice Gray. I would go further than my sisters, Justice Orenberg and Strauber, and I would reverse the Sixth Circuit and abolish the judge-made doctrine of qualified immunity. We got it wrong, but let us not continue to compound our mistake. The doctrine of qualified immunity is clearly a mess. We see that in this case and in the precedent. We have cases granting qualified immunity when an officer shot a woman armed with a knife 4 times. The Sixth Circuit granted immunity to an officer who released a dog and the dog fatally bit the suspect. Yet we are all appalled by the excessive force deployed in other cases. We made up the doctrine and have changed it over and over and over again over the years. Courts can't apply the doctrine consistently, and we can't give them any consistent guidance. It is not up to Congress to clean up the mess that we created. If Congress actually wants officers to have immunity from litigation in certain circumstances, Congress can enact a statute that provides us with guidance.
Thank you, Parvin. We will now go to Randall next.
Thank you, Justice Gray. As Justice Brandeis famously observed, sunshine is truly the best disinfectant, and so it is with the very well-intentioned challenge to qualified immunity that we heard today. We live in a period where advances in technology have focused probably more light than ever seemed possible to many of us on the problem of police misconduct. And this has given both the courts and I think the average citizen much needed insight into the tragic abuses of power that are all too often committed by unethical police officers. But the fact that our society and our justice system have much work to do on this front does not mean that we should abandon good precedent for nebulous gains. There's been no demonstration that abandoning qualified immunity would deter the behavior that so badly needs to be deterred. Bad officers are universally indemnified, but what will be deterred if we proceed down this path is participation in the much needed public service of law enforcement. I agree with the respondent that we need to focus more on criminal prosecution of bad officers who are undermining our system of justice and not proceed down a path with civil litigation that will only further overburden courts with limited benefit to society at large. This case was excellently argued on both sides, truly excellent advocacy, but I vote to affirm.
Thank you, Randall. We will now go to Lindsay.
Thank you, Chief Justice Gray. I would vote to reverse. To me, this is a case about the legitimacy of institutions. And on the one side, you have an argument that maintaining precedent is important for the legitimacy of the court and us as an institution. And on the other side, you have an argument that the doctrine of qualified immunity delegitimizes law enforcement and makes us as a country, as a society, feel as though our law enforcement officers can act with impunity to violate constitutional rights with no consequence. And I'm persuaded that this doctrine, because it's atextual and because it's only been around actually for 50 or so years and not for the life of the statute that it purports to apply to and to implement, hurts the legitimacy of us as an institution, of government and faith in government. And so I would vote to reverse, and I would reach the second question and say that this doctrine has long reached its end. It's time for us to abolish it.
Thank you, Lindsay. We'll now go to Bill.
Thank you, Justice Gray. My most significant concern is that a citizen has claimed they were injured in violation of the Constitution, and we don't really know if that happened. Qualified immunity is serving as a barrier to know whether people are being injured based on officials acting outside of what the Constitution allows. And I don't think really remanding for more fact development is enough, because I think that our inability to know what happened here is a bit a feature of how qualified immunity functions, which is it truncates the discovery process. So I would take a recommendation that was made by the petitioner here, which is to procedurally require that courts reach the question as to whether there was a constitutional injury. But I'm also sensitive to the idea that officers of the law need to be able to act quickly, that in the heat of the moment, there may not be perfect clarity. And so I would also suggest that there be a more developed sense of a kind of a good faith belief, something like Justice Zornberg suggested, which is an affirmative defense of good faith. So I would reverse with instructions under that the court reach the constitutional issue, and also that it allow the officers to explore in discovery this sort of good faith defense.
Thank you, Bill. We'll next go to Arlo.
I too would vote to reverse based on some of the same concerns articulated by Justice Zornberg and Justice Harrington. I just don't think the factual record developed to date establishes that the officers in question were entitled to qualified immunity. I would not go so far as some of my other colleagues in abolishing the doctrine. I'm going to stay out of the debate about whether it's a good doctrine or a bad doctrine. I think one can make arguments in both ways. It clearly needs reform, but I think that's a job for Congress. We have interpreted this 1983 statute to provide for immunity for 40-something years. I wouldn't throw out so lightly our past precedents. We've taken up qualified immunity cases 3 times in the last 20 years. We've issued rulings that have changed the standard in small ways, but to just throw it out now, I think does not demonstrate the respect this institution needs to demonstrate for our precedents in interpreting either statutes or constitutional provisions. I think we owe it to the citizenry to be consistent in that way. To me, the chief problem with qualified immunity is not that the doctrine is unsound, but that lower courts like the Sixth Circuit, perhaps hampered by some of the guidance we've provided in the past, have lost sight of the forest for the trees. I want to bring us back to Hope v. Pelzer, which was the 2002 case that said even though there was no precedent about an officer tying a handcuffed subject to a hitching post, that officer had clear and fair warning that that would violate the Eighth Amendment. Here in 2020, if a person has surrendered and the officer has notice of that, you can't assault that person, not with a dog, not with a chokehold, not with a knee. To me, there's a factual dispute, of course, about whether this person had surrendered. But if the facts establish that the officers were aware he had surrendered, then qualified immunity has no place in protecting their conduct here.
Thank you, Arlo. We will now go to Brooke.
Thank you, Justice Gray. I agree with my colleagues that there is not enough of a record here to come to a clear conclusion. And given that, I believe that we need to remand for further fact-finding, particularly in a situation where, as here, Mr. Baxter's request for counsel was denied throughout. However, turning to this court's precedent, we have made a mess. The doctrine of qualified immunity, as it has grown up in the courts, has become untenable. And quite frankly, the standard of clearly established violation of constitutional law is an indefensible doctrine at this point. I believe that Congress should act and should be clear in its intent in terms of providing immunity for police officers. That being said, we need in the meantime to provide better guidance to lower courts. And I agree with Justice Devlin Brown that a return to a prior standard that doesn't get into the mess of whether or not something is clearly established is the better place to be. Hope v. Pelzer provides that guidance, and we should return to that standard. We told litigants that they would have qualified immunity as long as they didn't violate a clearly established law. And then in later precedent, we decided that we would not determine whether or not something was a true constitutional violation. We cannot continue along this path. I am not in favor of abolishing the doctrine altogether because we as a country are in a place where we need to be holding both police officers accountable and the courts accountable. And I believe the standard in Hope v. Pelzer will help us strike that delicate balance.
Thank you, Brooke. This seems to be the rare case where we have broad consensus. I share the sentiment of Justice Jackson that this case was fabulously argued by both sides. And my views on this case is that it's a hard case in the sense that the weight of 50 years of precedent have led us to this moment where courts, as Justice Harrington indicated, are not even reaching the constitutional merits. They're using qualified immunity quite broadly as a shield, and frankly, our precedents have pointed them in that direction. And it's an easy case in the sense that some of my colleagues who have called for abolishing the doctrine have highlighted that the instability of our precedents lead to results where you have two different panels of the same circuit in a 2 to 3 year period reaching completely different conclusions in the same case. So I ultimately think the path that Justice Strauber laid out, which is to reverse and remand and make clear our precedents do not call for identical cases, and that faithful application of Hope in other cases is the proper way on remand for this case to be decided and for further factual development to occur consistent with that. I think that's the way that this case should be resolved. But I want you to know I intend to write separately because I join my colleagues, Justice Moyne and Justice Harrison, for thinking that it's time to rethink this doctrine. I don't think this is a good case to rethink this doctrine, but I cannot think of another doctrine where counsel in favor of the doctrine stands up in court, tells us that there's no foundation in text, she won't even try to argue it, where in the briefing there's no effort even made to argue that the Congress that passed the Ku Klux Klan Act was concerned about protecting these kinds of immunities at the time of enactment, where we have this kind of instability in our precedent, and it has the kind of real world consequences that we're grappling with. I think this court has reversed precedent on much less than that, and we should revisit this precedent. So as I see our votes here, listening to all of you, it appears we have 8 votes in favor of reversing the decision of the Sixth Circuit and remanding for further factual development. We have 1 vote from Justice Jackson to affirm the ruling below. And so going forward, the decision that I'm going to make is to assign this case to Justice Strauber to write the opinion for the court. It seems her position, as articulated, certainly carries a majority of those who would reverse. And I think several of us may write separate to call for abolishing the doctrine of qualified immunity.
Thank you all for joining OAD tonight. I want to thank all our participants, our honorees, our justices, and especially our brilliant advocates. Thank you also to the many sponsors who, without your support, we could not do this, we could not do our work, we could not do our programs. Please join our staff to continue the conversation in the post-video rooms. The links are below, and you can also click the donate button to continue to support us in our mission. Thank you once again, and good night.